My name is Jeff Ansel. I'm an attorney in Minneapolis at Winthrop Weinstine. I've been practicing law for 37 years. I practice in the area of commercial litigation and dispute resolution, and one of the sub-practice areas that I have been working in over the years since the 1980s is representation of receivers, and I've been asked to speak a little bit about that topic today. I know that in every jurisdiction there are different rules and procedures, and I'm in Minnesota, so most of my experience is based on the concepts and rules and laws in Minnesota. I'm going to try to keep the conversation very general and not get too specific because everybody's going to have different nuanced issues when they look at representing receivers. But I think these concepts are pretty universal and apply in most jurisdictions. When I look at representing a receiver, I see two categories of discussion. One is pre-receivership representation, that is representing the entity or company or person who is going to be proposed as the receiver, if that's what's happening. And then during the receivership, representing the receiver has different concepts. Before the appointment of the receiver, if you know that your client is going to be asked to serve in that role, it's important to do what you can to get an advance copy or draft of the proposed receivership order. The reason for this is you'll want to make sure that certain provisions are in the order that protect your client. You want to make sure that the order does not contain any sort of erosion of the common law doctrine of immunity. I've seen some orders where there's a proposition that the receiver shall enjoy immunity except for acts of willful misconduct or gross negligence. We don't need that in there. The law provides when a receiver loses immunity, and that kind of a provision is a significant erosion of what immunity typically looks like. Another important issue in reviewing the receivership order is to make sure you have for your client the right to seek instructions from the court. We have a statute in Minnesota that we passed in 2012, and I was on the committee of 18 people who worked on that statute, and we included a provision in the statute regarding the receiver's right to seek instructions from the court, but you want to make sure that you have that right either statutorily or in the order and that it's not eroded. And the last important thing for the proposed order on a very general basis, obviously there are powers and duties you'll want to review, but you want to make sure there's adequate provision for the receiver to be compensated and that there's an exit strategy if the receivership does not have funds to pay the receiver, either resignation or funding by one of the parties seeking the appointment. So those are some pre-receivership concerns or concepts that need to be addressed, and a good reason why you want to review that order before it gets entered on behalf of your client if you can. The second pre-receivership appointment issue is sort of a cautionary one. Many times receivers that get appointed have previously served in the role of a consultant to the debtor or the respondent that is the subject of the receivership, many times at the request of a lender. And typically those engagements are based on a written contract. My experience is this is a bad idea. For example, in Minnesota, there's a provision in our statute that requires that to qualify to be a receiver, the receiver must be independent. And it's not necessarily true that a pre-receivership consultancy arrangement makes the receiver independent. In addition, as a consultant, prior to the receivership, the proposed receiver has access to information that the debtor may think is going to be confidential. In fact, some of those consultancy agreements may contain non-disclosure provisions with certain exceptions. It's important that if you're going to serve in that consultancy role, it's really important in that contract that it says you can say, the debtor consents to being appointed as a receiver, and that the debtor understands that if that happens, the confidentiality obligation is off the table. That's because the receiver has an obligation to the court at some point and an obligation to the parties. And if the receiver knows information about the finances of the company, for example, obligations that aren't on the balance sheet or other information, as a consultant, you may be able to keep that to yourself, but as a receiver, you probably can't. So I always counsel clients of mine who are going to serve in that role that if they're going to do it, I tell them they shouldn't do it to start. But if they're going to do it, they need to make sure that they have proper contractual provisions that shield them from liability or claims if they are appointed as receiver. As a practical matter, I've seen too many cases where the subject of the receivership has expectations about what the receiver is going to do as a receiver based upon pre-receivership representation or consultancy arrangements, or even pre-receivership discussions and meetings about what the receivership might look like and why a receivership is a better way to go than some other avenues. And so they come away with the feeling that the receiver is on their side, and the receiver is on the court side, not on the party side. So that's a very important topic, and it has, in my experience, has resulted in litigation that really is not necessary post receivership. So those are the main pre-receivership issues. And then once the receiver gets appointed, the landscape changes. When the receiver gets appointed, the receiver is an arm of the court. That's an important concept. We all talk about it a lot, but it has significant meaning. At that point, as a lawyer representing the receiver, ostensibly, you are also representing the court. In fact, there is case law in Minnesota that says counsel for a receiver or professionals hired by a receiver enjoy the same quasi-judicial immunity that receivers enjoy because of the assistance they are giving to the receiver and consequently to the court. And in that regard, as a lawyer representing a receiver who's an arm of the court, issues pop up like, what about ex parte communications between you as lawyer for the receiver and the judge? What about ex parte communications that a court couldn't have with a party to the case? Can your client have those kinds of communications? And the answer is, clear as mud. On the judicial side, having communications with the court on an ex parte basis under the rules of judicial conduct in Minnesota, it is permitted. The applicable rule in Minnesota provides that an ex parte communication is okay if it's initiated by the court for purposes of talking to or communicating with people who are assigned to assist the court in its judicial function, which would include a receiver. With respect to parties, however, it's not quite as clear. Is it okay for a receiver to have communications with the plaintiff lender in the case who sought the appointment of the receiver about how the receiver is going to handle a certain liquidation issue or running a business? That's not entirely clear. I have tried to steer clients who are acting as receivers toward disclosure. In other words, if they're going to have those kinds of discussions with parties in the case, the parties have to know that the conversations and discussions are not confidential. That is, the receiver has an obligation to disclose the conversations and discussions. In fact, I worked on a matter where there was a dispute actually between the receiver and the respondent and the moving party, the petitioner under our statute, regarding whether or not it was appropriate to sell as opposed to lease certain condominium units that were in receivership. The lender wanted not to lease those. They wanted to keep them pristine to try to sell them and maximize value, but the market was terrible, and the respondent wanted to be able to lease those to get some income going, and the receiver agreed with that. So what do you do in that situation? First, the receiver disclosed to both sides what the other side had told them, and then the receiver sought instructions from the court on what to do, and that's a very powerful tool during the receivership. And that's one of the concepts I think that is critical when you're representing a receiver. If you feel like there's ambiguity in what the receiver is supposed to do based on the court order or applicable law, ask the judge. You can do it by a letter seeking instructions. You can do it with a predetermined outcome in mind and say, Judge, we'd like you to instruct us to do this and supply a proposed order. Or you can say, Judge, we're not sure what to do. Here are the competing interests. Here's what we recommend. Please instruct us. But getting court instructions is very important because A, it protects the receiver from anyone saying they did something that was not correct. And B, it takes away the perception of favoritism by the receiver. The receiver must be even-handed, and you must advise your client to be even-handed during the course of the receivership. The last topic I wanted to address about post-appointment issues is the issue of compensation for you as a lawyer. I've had cases where, because of the nature of the disclosure that was made at the beginning of the matter regarding who the lawyers would be and what their rates would be, have changed over time. Parties object to legal fees that the receiver is asking the court to authorize it to pay. So one of the things that we do here in Minnesota is, upon appointment, a receiver or the counsel that it hires files a notice of appearance and a notice of retention, explaining that they have been engaged by the receiver to represent the receiver, who the lawyers at the law firm are that will be working on the matter, and how the receivership is going to be billed, hourly, contingent, etc., and what the rates are. In order to avoid misunderstandings down the line, we try to include some language that allows some flexibility. So, and it's much like what you would do in an engagement letter. These are the current attorneys who we think are going to work on the matter. There may be others at different rates at different times, and the rates we're charging now are, set forth below. But we periodically change our rates, and the rates here may change as well. The court or the parties may ask that if there's going to be a rate change, you give notice in advance of that, or that if there's going to be a different lawyer working on the matter, that you give notice in advance of that, a week, 10 days, 2 weeks, whatever it is. But otherwise, it's important to have language that gives you that flexibility. Otherwise, you could end up litigating with the parties on your own fees, which is not a good thing for anybody. I think I said that was the last topic, and it's not. There's one other topic. It's more of a concept. The receiver is not a party litigant in the matter. This is something that the receiver always understands, I think, but the parties don't. And many times parties displace their anger or frustration that, for example, they're not going to get paid what they thought as a creditor, or when they're a respondent or a debtor, that their business is not being properly administered by the receiver, and they take shots at the receiver, bring claims against the receiver, bring motions against the receiver, etc. It's not to anybody's advantage to do that, because the receivership estate will pay for the receiver's fees and costs in that regard. And it's important to continue to advise your client and to impress upon the lawyers for the parties in the case that you are not there as their enemy or adversary. You're there for the purpose of and at the pleasure of the court. That should help ease some of that burden. Now, there are going to be disputes, and there could be claims brought against the receiver within the receivership, but most of those claims should be resolved by the receiver, qua receiver. In other words, there should not be personal liability for any damages or claims that are made against the receiver in that capacity, and the receivership estate should be the source of funds to resolve those claims, not the receiver's personal bank account. So those are just some of the overarching issues that arise during the course of representing a receiver. I hope the information is helpful, and if you ever have a receivership in Minnesota or have questions about the topics we've discussed, please feel free to get in touch with us. We'd be happy to help. Thank you.